Hello, welcome back. Today we are back to our reading session. Yesterday we stopped on just the titles, like we have many what we say, invention and creations like patents, trademarks, industrial design, layout design, semiconductor, integrated circuits, and so on. Today we will be discussing in depth. For example, today we will start with WIPO, that is the World Intellectual Property Organization, that was incepted in 1967 at Stockholm to protect the IPR throughout the world. Later, it became one of the agency of United Nations in 1974. WIPO frameworks as well as regulate the various policies concerned to IPR across the globe. The economic, social, and sustainable cultural development with preservation of biodiversity, traditional knowledge through a balanced and effective international IP system is main objective of WIPO. Besides this, it is responsible to harmonize differences amongst various countries, especially between the developed and developing nation, by amending international regulation so that each of them get a equal opportunity in emerging world. The second is patent. A patent is an intellectual property right granted to inventor by concerned government office for his novel technical invention. The term invention means solution of any problem in terms of development of a product or a process. Among the different types of IPR, patents are considered the most valuable, and rightly so. The patentability of any invention needs to fulfill following criteria. First is usefulness. Invention must have industrial applicability or applied for the practical purpose. Second, novelty. Invention must be new technology which has not been published or available in prior art of the country or elsewhere in the world before the date of patent filing. Second and final point is non-obviousness. Invention which can be done by any ordinary skilled person is obvious and cannot be patentable. Hence, invention must not be obvious for patentability. As per Section 3 of the Patent Act 1970, the following are not patentable. First is frivolous invention. Next, invention against the natural laws. Then, invention which are not fair to health of human, animal, plant life, environment, as well as contrary to public order or morality. Next, discovery of any living thing, discovery of any non-living substances occurring in nature, formulation of any abstract theory, discovery of any scientific principle, substance or chemical obtained by mere admixture resulting in the aggregation of the properties, mere arrangement or rearrangement of known devices, invention relating to atomic energy and related to security of India. In patenting process, at one hand inventor is granted exclusive right which give recognition as well as the financial benefit. But at the other hand, inventor has to disclose all the relevant information in descriptive way to the patent office at the time of filing patent application. The information available in patent document can be seen by anybody, and no doubt it gives direction to other researchers to innovate further in the relevant field. In India, Office of Controller General of Patent, Design and Trademarks govern the patent registration process. This office comes under the Department of Industrial Policy and Promotion, Ministry of Commerce and Industry. The patent filing steps are as follows. Step 1. Filing of patent application or priority application. There are 4 patent offices at Chennai, Bombay, New Delhi and Calcutta. The Calcutta one is the head office. The applicant has to file the patent application in appropriate form with all relevant information concerned to invention such as description, claims, drawing, abstract, etc. Application has The applicant has option to file the provisional specification to establish priority of the invention when disclosed. Invention is only at a conceptual stage. Thereafter, within the 12 month applicant have to file a complete specification in prescribed format. The step 2, after filing a patent application or the priority application, the step 2 is publication of the application. The patent application is published in the office journal after expiry of 18 months. The applicant can also put up request for early publication by paying an additional prescribed fee. Step 3, opposition of the patent. The pre-grant patent opposition, if any, may be filed within the 3 months of patent publication. This type of opposition representation is entertained by Controller of Patent Office. If patent filing applicant has put up a request for patent examination, there are also provisions for post-grant patent opposition. The step 4, request for examination. The applicant has to apply separately for patent examination within 48 months of filing a patent application with prescribed fees. Step 5, examination and clarification of raised objections, if any. So the patent examiner check all the aspects of patentability, that is whether they have the novelty, inventiveness, non-obviousness and industrial applicability and issue. First examiner report, that is FER, to the applicant. If the objections are there in the examination report, then applicant has to clarify the objections within 1 year. The step 6, that is grant of patent. The patent is granted to applicant by the controller after overcoming the objections raised in examination process. As per the Patent Amendment Act 2002, the applicant has to pay renewal fee to time to keep patent in force. The full details pertaining to the Indian patent can be referred to DIP and P website. The patent can also e-filed since 2007. After getting the rights, the owner can explore the rights by industrial production or can sell, distribute or license the rights as per his will. The rights of patent are granted for 20 years. Once the patent expires, then the invention enters into the public domain and anybody can use that knowledge. Compulsory license. The Patent Act gives monopoly to inventor to harvest financial gains for invention. But contrary, in case of national emergency, as per Section 92 of the Patent Act 1970, government can issue compulsory licenses to third party for non-commercial use of public. Besides this, when authorized patent owner is not fulfilling the demand of society by will or unable to produce the patentable product or service, such as in case of drugs, food, medical equipment, vaccination, life-saving equipment, etc., the government is fully authorized to allow somebody else to produce the patentable product by giving the compulsory license. In this case, the government is liable to pay fair, justifiable economic benefit to patent owner. Patent Cooperation Treaty or PCT. So I hope the patent steps are clear till now. If there is any doubt regarding any of the steps or statements discussed above, please post your comments so that we can discuss more. So next is Patent Cooperation Treaty or PCT. The patents are territorial rights. Therefore, applicant has to apply patent application to patent offices of different countries individually. This practice requires huge amount of investment, time and energy. In the same concern, Patent Cooperation Treaty, that is PCT, concluded in 1970, which provides a facility to file a single international patent application instead of filing separate national or regional patent application. Although granting of patent remains under the national or regional patent authorities of various PCT member nations, but applicant get the priority date of first filing applicable in all the member countries, which is more than 145 in number with this single patent application. Industrial design. The creative activity of achieving an ornamental or aesthetic appearance of mass-produced products or articles is covered under industrial design. The design can be expressed either by 2D or the 3D forms. The Design Act 1949 of the United Kingdom refers to feature of shape, configuration, pattern, ornament, or broadly shape, surface, pattern, lines, color, etc. appearance related features of industrial products such as watches, vehicle, mobile, laptop, different home appliances, buildings, textile design, or handcraft products are covered under industrial design. The aesthetic value or how a product appeals is the main concern in selling, besides its technical quality or other aspect. To be protected under most national laws, an industrial design must be new or original and non functional. Hence, industrial design is only concerned with the aesthetic features and any technical features or aspects of the product to which it is applied are not protected by the design registration. Although the technical features, if are novel, would could be protected by getting the patent. Beside this, design, which is literary or artistic in character, such as cartoon, label, leaflet, map, dressmaking patterns, etc., is protected under the copyrights instead of industrial design. The term of industrial design rights vary from the country to country from 10 to 25 years. In India, as per the Design Act 2000, duration of protection of industrial design is for 10 years. The duration can be extended further for 5 years. And industrial design encourages creativity and skill development amongst the individual and manufacturing sector by promoting more aesthetically pleasing products for the society. The design and shape of the product not only create aesthetic appearance, but in case of machine, furniture, automobile, etc., design is also indirectly associated with ergonomics and play a major role in customers' comfort. The patent offices at Chennai, Bombay, New Delhi, and Calcutta also deal with the industrial design. The Patent Office, Calcutta, maintain a register of design as statutory requirement for all concerned information or filed industrial design. Now we are moving to the other point, that is trademark. A trademark already existed in the ancient world. The Indian craftsmen used to engrave their signature on their jewelry or artistic creation around 3000 years ago. With industrialization, the trademark become key factor in modern world of international trade. A trademark is a distinctive sign or logo that denotes about the particular item is produced or provided by a specific person or industry or enterprise. Similar to trademark, service mark distinguishes service providing enterprises with their competitors. A company may have different types of trademarks for their various products, but to distinguish themselves from other company or enterprise, trade name is being used. Trademark or trade name helps companies to make their recognition, reputation, and trust amongst the customers. In most of the cases, customers rely on trademarks, where it is difficult to inspect a product or service quickly to determine its quality. A particular segment of customer is very much concerned about the brand and pay heavily for brands prestige even for the similar sort of quality to distinguish themselves from the crowd. A trademark or a service mark comprises of words like name, surname, geographical name, slogan, etc. Letters and numerals, drawing logo, simple phrase, image and design, or a combination of those elements to distinguish a business or service from the other. Beside this, there are certain other non-traditional trademarks as follows. Smell or olfactory marks. The smell of a fresh cut grass for tennis balls, the odor of beer for dart flights, and roses for tires have been registered in the UK. Similarly, the fresh floral fragrance reminiscent of plumeria balsam were registered in US for sewing thread and embroidery yarn. Audible sign or sound marks. The distinguished sound marks in form of a musical note can be registered as sound mark. The NBC successfully registered the musical note as a trademark in 1950 for its radio broadcasting services. The lion's roar is also registered as a sound trademark for MGM. Colored marks. The category includes words, devices with their color combination or color as such. Similarly, few taste and shape. 3D signs such as three-pointed Mercedes star as non-traditional trademarks can also be registered in some specific cases. So that's all for today. Tomorrow we will be coming back with the remaining read. Till then, stay tuned. Thank you for hearing and listening to us. Thank you so much. Thank you. Bye. Take care.